Good morning, this is your Kelso Report for Tuesday, July 17th, and I'm your host, Clark Kelso. We begin today with a case involving foreign sovereign immunity. Two oil companies sued the Republic of Iraq for allegedly unilaterally terminating two contracts for the purchase and sale of Iraqi oil. The district court held it had subject matter jurisdiction to hear this action, notwithstanding Iraq's assertion of sovereign immunity under the Foreign Sovereign Immunities Act, because the lawsuit, according to the district court, fell within the commercial exception to that immunity. In Tehrankian v. Republic of Iraq, a split panel of the Ninth Circuit reversed, holding that the lawsuit is not based upon commercial activity by Iraq in the United States, nor upon an act in connection with such commercial activity having a direct effect in the United States. Absent that direct nexus to commerce within the United States, the commercial exception to sovereign immunity does not apply. The dissent took the position that because the contract was executed in New York and payment was to be made in New York, that was sufficient contact with the United States to trigger the commercial exception. Next case involving criminal procedure, venue. In United States v. Pariseau, the defendant was convicted on a single count of attempted possession with intent to distribute more than 500 grams of methamphetamine. The district court denied the defendant's motion to suppress evidence of the drugs that were discovered strapped to his legs when he exited a plane in the Seattle airport. The Ninth Circuit affirmed, noting that upon being informed that he would be detained while they got a search warrant, the defendant said, quote, "You may as well just search me now," close quote. Now, for the Ninth Circuit, that constituted clear consent. But the venue decision is why the case was published. The Ninth Circuit rejected the defendant's challenge to the venue in the District of Alaska, noting that the crime of attempted possession with intent to distribute is a continuing crime. The Ninth Circuit cited all sorts of evidence in the record showing that the defendant undertook substantial steps in Alaska toward completion of the crime, even though he was arrested in Seattle. Now we turn to the California Supreme Court, which had three decisions yesterday. First, involving victim restitution. In People v. Runyon, the defendant, driving while intoxicated, killed another driver instantly in a freeway collision. The accident victim left no surviving family, dependents, or heirs. The defendant was convicted and sentenced to prison. The issue before the Supreme Court was if, when, and to whom one convicted of a felony is required by the Constitution and statutes to pay restitution to the estate or personal representative of a victim of the crime who has died. Noting that the estate was not itself a direct victim of the crime that caused the decedent's death, the court held that mandatory restitution was not payable to the estate for economic loss the estate itself had sustained as a result of the death. While a personal representative may be entitled to collect mandatory restitution on the decedent's behalf for economic loss the decedent personally incurred before death as an actual victim of the defendant's criminal conduct, there was nothing in the record to show that the decedent in this case, who was killed instantly, suffered any economic loss. It's a little bit like the wrongful death problem. So the Supreme Court reversed the entire mandatory restitution order that the trial court had entered. Next, case arising under Penal Code Section 664A. In a 5-2 decision, the Supreme Court in People v. Favor held that Penal Code Section 664A's increase in punishment for willful, deliberate, and premeditated murders can be triggered in a case charging robbery as an aider and abettor, where the commission of the attempted murder was a natural and probable consequence of the robbery crime. The prosecution does not need to establish that attempted premeditated murder was a natural and probable consequence. It is enough, based on the cases, that the attempted murder was a natural and probable consequence. You don't have to establish that premeditated element as a natural and probable consequence. Next, we have a death penalty case. The defendant in People v. Riccardi had been found guilty by a jury of the first-degree murders of 2 women by use of a firearm during the commission of a burglary. The jury fixed the penalty at death. The Supreme Court unanimously affirmed the conviction in a 124-page opinion, but it reversed the judgment of death because of the erroneous excusal of a prospective juror during jury selection. And the federal rule is that an improper excusal in a capital case requires reversal of the death penalty without any analysis for prejudice. So, not being able to invoke the usual harmless error analysis, the Supreme Court was forced to reverse the penalty while affirming the remainder of the conviction. And that's it for today's Kelso Report. Have a great day in the law.